Artificial intelligence can call to mind images of androids from science fiction and the questions about humanity that they suggest. AI, in that sense, isn't here yet, but similar precursor technologies are already in use and will be affecting the law and society now and in the near future. We will concern ourselves with the decision-making algorithms that provide recommendations or instructions for human actors. These are often complex systems that take enormous amounts of data as input and whose decision-making process will respond adaptively to new information. A cluster of related technologies that may be referred to as big data, machine learning, neural networks, or, of course, AI, are increasingly everywhere. They can take on specialized tasks in larger processes, like recognizing faces in photos or provide advice on a whole process. We see algorithms at work in finance, in medicine, and in legal decision making. Some of the hope in this technological change is that machines can be better decision makers than humans. They don't ration their own cognitive or emotional resources, and they don't make the same mistakes as we do. They can be more objective, less biased, and perhaps fundamentally more fair. But early indications suggest that, at least for now, this is a false promise. The issue is that we humans provide the only examples from which these machines can build their heuristics. Our selection of input data can reflect our own blind spots, and sometimes it's hard to find any sample free of human biases.
Forms of systems that evolve under their own rules in ways that might be unexpected even to the creator of those systems, that will be used in some way to substitute for human agency in a lot of instances. And that substitution for human agency might be something that is quite autonomy enhancing for humans individually or in groups. If you have a system that can worry about stuff that you don't have to worry about anymore, you can turn your attention to other, possibly more interesting or important issues. Something might actually have terrific predictive power and then also, by some accounts, be incredibly biased. If we take as a hypothesis that the police may be more likely to arrest one type of person or one ethnicity over another, then the baseline recidivism rate on which you would say, is this disproportionate or is it fair, is itself influenced by the behavior of law enforcement before something even enters the courthouse. And thinking about how you would try to adjust for that, if at all possible, in an algorithm, I think is a deeply profound and difficult question.
Earlier this year, the New York Times reported on the use of an algorithm in Wisconsin state courts that estimates the recidivism risk of a criminal defendant to guide a judge's sentencing decisions. We can't know for sure because the algorithm is licensed to the state by the private company that produced it and is proprietary. But presumably, it bases its risk calculations on historical recidivism data. But those data come from a history in which race and gender are measurably correlated with outcomes. One study found that the Compass algorithm actually overestimates the recidivism rate of black defendants relative to what we actually observe. This unreflective algorithm may be more biased than many human judges. So there's a real risk that these algorithms will simply replicate or amplify the biases present in the data we provide them. Even more concerning, we may be building systems that preserve and replicate our own biases and blind spots, but with the appearance of neutrality and fairness. And this is where we get back to tort law, because when algorithms assist with decision making, we will still see bad outcomes. Some people will be harmed, and policies will have disparate impacts based on sex or race or age or ability. But our usual ways for identifying responsibility look all muddled. The complexity of these systems makes it hard to assign blame to the people who use them, since these people may have been simply following the recommendations of a machine that they believed knew better than they did. The aura of legitimacy around science and technology works against us here. It is easy to imagine a court finding that it is reasonable for a doctor or judge or investor to defer to a well-designed algorithm, one that's been exposed to far more information than any human professional could. And the law also cares about foreseeability when deciding whether human actors would have been negligent. The whole point of these systems is to consider more information than a human in their situation could. And if they succeed at this, their conclusions will be somewhat unforeseeable to their users and creators. So when algorithmic decision making harms people, it may be tough to show that those who could have prevented it were negligent. And of course, without foreseeability, any concept of intent is even more remote. So this is one concerning vision of where artificial intelligence, as a decision maker, may lead. A world in which many of the same risks and harms are present, but replicated through machines that obscure responsibility, that distance human actors from the harms they create. In an interview, Professor Chris Bavitz discussed a hypothetical private company using a machine learning algorithm to guide its decisions about employee salaries, bonuses, and promotion. If this policy resulted in pay inequities between men and women, how would the law treat this case? Even if the algorithm didn't explicitly consider gender, it might find another factor that functioned as a proxy for gender. But the algorithm itself might be so complex that it wouldn't be apparent to the company or to a court that this was happening. And that's assuming they could even review the functioning of the algorithm. Proprietary software is often a black box to its users. Professor Bavitz is still hopeful that decision-making technology may reduce bias overall, but emphasizes that it's important to create transparency about how these tools work. Even then, as these technologies become more accurate, they will also become more complex, and it will be harder for us to understand just what they're doing. Complexity may be an argument for imposing stricter liability standards on those who create these tools. We may wish to place a burden on the creators to better incentivize them to find ways to reduce the risk of algorithmic bias, since it's difficult for anyone else to show how the problems arose, much less prevent any harms. We are hopeful that these tools will get better over time. We hope to see these technologies developed so that they reduce accidents and produce fairer outcomes overall. But notice that this hope is about the pie getting bigger, about efficiency, but not necessarily distribution. What if algorithms bring us a safer world, but most of the safety gains accrue to white people, or wealthy people, or Americans? And when others realize they've been neglected, these very successes make it more difficult to hold any human actors responsible. In the years to come, we will have to consider whether that's an acceptable outcome.
My prediction is that legal theory is going to be, and legal theorists in the law are going to be focused on this and struggling with this and entangled in these difficult questions going forward for who knows how long.